Schulich School of Law, Dalhousie University, and one of the editors of Afronomics Law. We have put this event together as a team with the Viscount Bennett chair at the Schulich School of Law, but also in particular with authors and panelists today. Our aim really is simple, to number one, celebrate the two books that have been at the center of the conversations we'll have today. But number two is to really continue to shed the light on the important work that many, beyond those who are in this panelist today, some in the audience. I see Professor Onyema, Professor Fola Adeleke, amongst others, who have worked seriously on international investment law and arbitration in Africa are doing. And so today we plan to go with the authors first in terms of order, having their own intervention about the books that they have authored, and then we'll go to the Q&A with our panelists. And we hope to have some time at the end for you, the audience, to have your own questions as well. And so even if the questions occur to you while we're going on, we do encourage you to just type them in, as there may not be time for you to intervene verbally. So before I start, let me read a paragraph or two from the two books. The first one is from this one, which is the book by Dominic. At page 3, he says, now I quote, I argue that African states need for autonomy to regulate in the public interest in the areas of, number one, development, number two, human rights, and the environment must limit the type of treaty-based standards of investment protection they can undertake. He says, accordingly, given their heavy constitutional responsibilities to public and public interest first in all their decisions and actions, including in international business relations, African states must not agree to investment treaties. He says they must not agree to investment treaties that directly or indirectly prevent or constrain them from performing functions constitutionally required in the public interest. He proposes express and implied limitations placed on investment treaty-making powers of African states. Once we move a little bit along, there is this other book I have in front of me, which is the one by Professor Kidane. And he, at page 8, I was going to read 2 sections, but I'll stop at this one so that I can flip it out. He says, at this moment in history, Africa is reckoning with its post-colonial choices and charting its future course of action. The newly adopted African Continental Free Trade Area is an embodiment of its contemporary outlook. As of this writing, its member states are negotiating a protocol on investment. Whether African states succeed in agreeing on a continent-wide investment protocol or not, Africa currently finds itself at a stage where it needs to critically appraise its existing investment law regimes and evaluate the choices that it has made. This book aims to critically evaluate past choices and providing analytical tools for the formulation and execution of future directions. Well, ladies and gentlemen, that explains why today we're really looking at, the future of international investment law in Africa. And without much ado, I'll briefly introduce our panelists and then move on to the Q&A. We have with us Professor Dominic Dagbanja. He's a senior lecturer at the University of Western Australia School of Law. He's also an author. Congratulations. Professor Kidane, Professor of Law, Villanova University, Charles Widger School of Law. Congratulations, Professor Kidane. Professor Ibironke Odumosu-Ayanu, Professor of Law at the University of Saskatchewan College of Law. Thank you very much for joining us, Professor Odumosu-Ayanu, and for all the terrific work you've done in this field. Professor Kehinde Olaoye, she's an assistant professor at Hamad bin Khalifa University College of Law in Qatar. Thank you very much for joining us this morning, and we look forward to hearing from you. And last but not the least is Dr. Harrison Mburi, who is a research fellow from what will now be the Luxembourg University, but still in transition, Max Planck Institute, Luxembourg, for International, European, and Regulatory Procedural Law. And so with the introductions done, I'd like to turn to Dominic to start. Dominic, you have 10 minutes to share with us briefly, right? The maybe core ideas, themes, arguments, to just help an audience who has not otherwise read your fascinating book understand the issues you put on the table. Thank you.
Okay. Let me say thank you so much, Professor Olabisi Akonkobi and Afronomiclaw.org Academic Forum for providing this precious opportunity for me and other colleagues on the panel to share our ideas on these two important volumes on Africa and international investment law. It's an opportunity for those who otherwise are not aware of the books to become aware they are in place and to utilize them, because we have written them to contribute to the scholarship and public policy making in the area. So I'm very pleased to have this opportunity to speak to my book. The book was published, my colleague has already shown you, the book was published in 2002 by Oxford University Press. And the context of that book is that it developed out of my PhD thesis at the University of Auckland. And so I'm grateful to my PhD supervisors for the support. Initially, the focus was on Ghana, but I expanded it to include a reasonable number of other African countries. And the context of that book is the fact that states often get sued by foreign investors in international arbitration involving public policy matters, even on constitutional issues. And so what I seek or sought to do in this book is to engage with the intersection of public policy and law and international investment treaties. And I think it is settled in public law that national constitutions are supreme in the hierarchy of legal norms within the domestic context. And the governmental actions, including in the making of investment treaties, are supposed to be carried out within constitutional limits. So the question that I addressed in this book is whether the principles of constitutional governance and the right to regulate in international law should place limitations on the capacity of African states to conclude international investment treaties. So that is the question that I raised. And in doing so, I examined 4 fundamental areas: the judicial systems in Africa, human rights, the environment, and development. And I developed what I call the imperatives theory, which is a framework for explaining and dealing with the issue of conflict of legal norms and interests in international investment law. And the issue addressed by the imperative theory is whether the fundamental obligations of African states towards citizens under their constitutions should or place certain limitations when it comes to the conclusion of international investment treaties. And I think that is important because if you review the constitutions of various African states, Nigeria, Egypt, Cameroon, Ghana, Kenya, and so forth, you will find that they place the public interest, the welfare of the people at the center of constitutional governance. So the question that arises is whether, given the central role of the state, the central duty of the state to put the public interest first in constitutional governance, African states can still nevertheless conclude treaties that limit the exercise of their constitutional and regulatory powers. That is the question at the center of this book. And so I argue that on the basis of constitutional general international law imperative theory that I developed, I argue that African states have limited capacity to conclude investment treaties that constrain the exercise of their regulatory powers. And I've done a detailed analysis on involving the various states that have engaged: Cameroon, Ghana, Kenya, Egypt, Nigeria, South Africa, and so forth. And you will need to go to the book and look into the details. So my central point in this book is that African states lack the capacity to constrain themselves merely because they seek to protect foreign investment. That is the central point that I made in this book. And in terms of my overall argument, and please draw my attention in case I'm getting out of time, my good friend Olabisi. Now, what I did in this book and my research generally is to argue against the conclusion of investment treaties. And I think I have taken a view that is unpopular in the international investment law scholarship. And I'll give you a number of reasons why I argue against African states concluding investment treaties. Number one, the case for the conclusion of investment treaty is that they attract foreign investment. And following that, it is argued that foreign investment leads to development. So that is the basic thing. And if you look at the preambles to various investment treaties, they do make reference to development, prosperity, and so forth. But the literature is not certain on whether or not investment treaties do attract foreign investment. And indeed, in an article that I did on Ghana, I found that most of the investment that were made in Ghana at the time that the article was written were made by countries, foreign investors from countries that Ghana did not have investment treaties with. And so the argument that if you don't have investment treaties, you cannot attract foreign investment cannot hold. Again, the thesis is that the argument in support of investment treaties is that they lead, foreign investment leads to development. Now, the first bilateral investment treaty was concluded between Pakistan and Germany in 1959. And African countries have been party to that right from the inception. For example, the Niger-Switzerland bilateral investment treaty was signed in March 1962 and entered into force in 1962, about 4 or 5 months after the first bilateral investment treaty was entered into force. And then the Togo-Germany bilateral investment treaty was signed in 1961 and entered into force in 1964. The Ivory Coast Switzerland bilateral investment treaty was also entered into force in 1962. So the point that I'm making is that African countries have been party to this agreement right from their inception. So if the theory that foreign investment treaties attract foreign investment and that foreign investment leads to development, then African states will be developed states, including Pakistan as well, which concluded the first bilateral investment treaty. But we all know that is not the case. So that is one of the points that I hold against African countries concluding investment treaties, namely that they do not attract foreign investment and foreign investment does not lead to development. The other argument that I make against the conclusion of investment treaties is that there is no reciprocal benefit for African countries in signing these treaties because African countries are investing less or not at all in the countries with which they sign these investment treaties. And if you don't have foreign investors investing in those countries, then the reciprocal benefits that are available will never be received by African countries in any case. So I say that there is no point in concluding bilateral investment treaties. Number 3, my third point against the signing of investment treaty is that they provide a basis for public policy measures to be challenged in international arbitration. So measures relating to tax, measures relating to environmental protection, indigenous rights, and so forth. And there's a lot of public money that is spent in defending these cases. So for example, in UCOS against Russia, Russia was ordered to pay $50 billion to cover the cost of the arbitration, including paying counsel and so forth. I believe you see that an entire African country will collapse if this huge amount were awarded against an African country. So public policy measures are being challenged under these investment treaties when the benefits deriving from them are uncertain. So that is another point that I hold against investment treaties. And then I also think that foreign investors already enjoy legal protection under domestic law. For example, in Ghana, we have the Ghana Investment Promotion, Investment Promotion Center Act, which is designed to provide protection. And many other African countries have their domestic legislation specifically focused on foreign investment protection, including protections against expropriation. They also give foreign investors the right to challenge states in international, to go to domestic courts or even in arbitration to resolve their disputes. So legal protection is already available for foreign investors under investment treaties, and there's no point in agreeing to these terms.
Okay.
And then I also say that it should be troubling to...
sorry.
My time is exhausted.
Yes, you would have
Okay.
the opportunity to put these ones on the table again. But what we're trying, thank you very much for those initial reflections.
All right, thank you.
That derive from your book, The Investment Treaty Regime and Public Interest Regulation in Africa.
Thank you.
Those issues are, if one were being very conservative, mildly contentious, right? But I think it gives a very good segue to Professor Juan Kidane's book. Because you've rightly noted and you've taken a position that many will agree with you on that. Maybe African states don't need to conclude these treaties for all of the reasons you've so well marshaled. Yet they continue to do it, and so there's a case of living with the reality here, despite the promise that the regime offers. Professor Juan Kidane, I wonder if you want to now come in, right? Not that your book responds in any way, so I want to be clear that's not what I'm trying to say. The book makes its own argument, and I do want you to give us, your own reflection of the argument you've made. You've drawn on different theories, regime theory, international relations, in writing this particular book. Your own 10 minutes starts now. Thanks.
Thanks, Visi. I appreciate the opportunity. So I agree with many of what Dominic has just described, but my book is an overall assessment of why the African states have become a part of the system, what the system is itself, and how did they do in the last 60 to 70 years, and what do the reform efforts look like. So the foundations of the legal regime begins with what is called the gradual legalization of North-South relations. During colonialism, as we know, colonial capital is protected through direct rule, through coercion. So once that actually passed, then of course legal instruments were used to order the relationship between the North and the South. What they do essentially is prescribe external legal standards and outsource the decision-making process, right? And the essence of that is waiver of immunity by the states and the possibility of arbitral awards that could be enforced across jurisdictions. That is really the system that we have now, right? So Africa has almost unanimously supported, and many of us have studied the history of exit and found that the Africans overwhelmingly supported the system. And that was essentially because of what Dominic touched upon earlier. The idea then was that it would encourage investment, right? Did that happen or not? is something that we're still studying. Dominic seems to have made it his mind that they don't. But there are others who actually argue that there is a way that they could actually, in many ways, encourage investment. Now, as a preliminary remark, I'd like to mention that one of the supporters of the ICSID treaty or convention was none other than Judge T.O. Elias. And Professor Olavisi Akinkube, in one of his writings, says that, I'm quoting him directly, because Elias sought not to reject international law for its legacy and participation in the colonization of Africa, but rather sought to use these legal tools as best as he could to reform international law to serve the newly independent countries. The question really is, was international law used to reform these rules, norms, to benefit Africa? So fortunately, we have an extensive corpus of data that we can continue to study as to what exactly happened. How did the African states do? They supported it. They became a part of it. Latin America completely rejected it. We all agree at this point that without African support, ICSID would not have come into existence. It wouldn't have been possible. So once they became a part of it, then of course they started answering charges of expropriation, violation of FVT, and other principles of international investment law. And this data is rich. We're talking about 180 cases decided in Washington, D.C., mostly in Washington, by ICSID tribunals. What I've done in this book is study a portion of that. The methodology that I used, obviously, is very straightforward. I selected only those awards published in English, those that have been concluded. I found the ones, I think they range from the early 1980s to 2022, and 144 cases were completed, and I could only find 30 that were published in English. And I analyzed these in the book thoroughly. And I encourage those scholars, the PhD students who are actually studying in this area, to actually look at the French cases. I tried to do that. I got most of the French cases translated, but I didn't include them in the book. So what do we find in these cases? What evidence do they provide? So the first 2 decades, the Africans literally boycotted the proceedings, and they lost almost all of the cases. They didn't even participate. The starting point, obviously, this is not an ICSID case, but the foundation Libyan oil cases, that's where it all started. Those are the foundation cases for international arbitration generally, not limited to Africa. What happened? Libya didn't participate. And of course, the decisions are what we know what they are. So 1980s, 1990s, almost all of these cases have been lost. Why? Africans were not represented. They literally boycotted the whole system. But proceedings continued, awards were made. Those are mostly default judgments or default awards. But somehow, in the early 2000s, they started participating in these proceedings. And not only did they start participating, they started winning cases in large numbers. So some of the cases that are most familiar, World Duty Free, for instance, for Kenya, WENA, and this a number of different cases. And in fact, in the 2000s, Africans won half of the cases. They continued to do very well in the post-2010 period. The participation. So the more they participated, they started winning cases. And of course, tribunals became a little bit more careful, right? Now let's take a look at the statistics on who were the decision makers. Part of the problem was the substantive standards. They usually come from bilateral investment treaties, Sometimes there are just contracts-based ISDS and the contract selective applicable law, mostly English law or something outside of Africa. There's only one case that I saw that selected Guinean law. In any case, who were the decision makers? So 88 decision makers decided the 30 cases. 80 of them were actually Westerners. Only 8 were outside of the that category. And there were only 4 Africans, and there were only 4 women. And there was no tribunal that was chaired by an African, and there was only 1 tribunal chaired by a woman. So there was this glaring lack of diversity in the decision-making process. And how about principles? How did they do? I tried to look at the application of, for instance, expropriation and FET principles in each one of these 30 cases. My discovery is very interesting. If you look at these cases carefully, what you will find is that these principles are some type of pretext to get to ex aequo bono in international law. They try to explain the principles, whether it's stated broadly or narrowly. At the end of the day, the decisions, most of them, by my reckoning, are actually ex aequo bono. Although the treaties clearly say that unless the tribunals are authorized, they must not do that. So I don't have a lot of time to get into the details of this, but I'd like to share some observations in terms of the use of the FET principle, expropriation principle, and how they actually ended up. And here's what I say in the book. I say the quarrel with the FET standard, at least in the African context, I conclude seems misplaced. We hear a lot of times that, oh, FET is the culprit. So in all of the reform efforts, try to redefine it or even eliminate it. I will say a few words about that even in the AFCFTA protocol. But was FET really the culprit? And in how many cases the tribunals used these principles to actually find against the respondent state? So those are the kinds of questions that I look at. And my finding is very surprising in a way that I haven't really seen any cases that could actually be blamed on the FET principle. So I'll come to that in question and answer if need be. But now, having gone through these proceedings, now African states started reforming at the regional level primarily. So I say the regional reactions were actually very extensive and related primarily in redefining substantive standards. So I'll fast forward in the interest of time, go directly to what the protocol has done. The protocol has actually eliminated the FCFTA investment protocol, that is, eliminated the FET standard. But it added its own confusion. And I can't resist the temptation of actually reading this into the record. It says this is administrative and judicial treatment. In the state of FET, what it says is administrative and judicial treatment. This is very good, but because it limits it, right? It says each state party shall ensure that in administrative and judicial matters, investments of another state party are not subject to treatment which constitutes a fundamental denial of justice in criminal, civil, and administrative adjudicative proceedings, an evident denial of due process, and a manifest arbitrariness, a discrimination based on gender, race, or religious beliefs, or an abusive treatment in administrative and judicial proceedings. So that really is what African states understand to be the FET principle. Now, some tribunals in other cases, I have not in the cases that I've reviewed, have actually read FET standard expansively beyond their limits, and then, of course, made awards. Now, this is the understanding that Africa has, at least, This is the codification of its understanding of the FET standard, whether in existing treaties or in the future, right? I understand this, and this is a very good one. But the drafters didn't stop there. They introduced another confusion. They say in subsection 2, for greater clarity, paragraph 1 shall not be interpreted as equivalent to fair and equitable treatment. For further clarity, they say, includes the minimum standards under international law. So that actually, we're going to be litigating this in the future in any case. But in any case, I like the previous paragraph, and I see busy. I may have run out of time, and I'll get back to some of these issues in question and answer. But thank you very much. Appreciate it.
Okay, thank you so much, Professor Kidane. You know, if it were left to me, I would say, you know, let me just keep quiet and keep listening to you, especially as you start getting into the FCFT investment protocol issues that are on the table. But I think we'll circle back to some of those issues in due course. And if you're just joining us, you know, the 2 books are on the menu table this morning. My camera, you know, are here. Anyway, it's blurry. Okay, I'll read them out. Africa's International Investment Law Regimes by Professor Kidane. The Investment Treaty Regime and Public Interest Regulation in Africa by Professor Dagbanja are the 2 books that are at the heart of the conversation today. And now, without wasting much time, both authors have put on the table some of the thoughts, findings. It is interesting to know that, you know, FET is not the culprit here, amongst other points that you have raised. I think the data that says, you know, 88 arbitrators, 80, you know, Western, and only 4, you know, African and African women, you know, it's interesting anyway, for us to have all those nuggets come out of the book, and very interesting reasons to go for the book. But I'll move now to our panelists. What I like about these panelists is they've had a long time to read these books. We've been in conversation since last year, right? So I'll turn first in this first round to Dr. Otieno. And, you know, my own question in this phase for you, you have 5 minutes, and I'll try to be strict with that, is, you know, to invite you to reflect on Professor, you know, Kidane's book. I know you edited a special issue recently. Congratulations with Professor Kathy on international investment law. I know you've written on something called Africanization. And I know your doctoral thesis as well engaged with some of these questions significantly. And so, you know, in this first round, which is, you know, mainly thematic, normative, and theoretical considerations arising out of these books, as you see, the authors have tried to tease some of them out. I wonder what your reflections are having engaged with at least Professor Kidane's book. Thank you.
Okay, thank you so much, BC, and thank you so much, Juan and Dominic, for those wonderful overviews of the book. I thoroughly enjoyed reading these books. I have to say I did finish reading Juan's book. It's quite something, and I had to sort of skip some chapters so that I get to, you know, some of the questions that I had. But I completely enjoyed this, and I agree with Juan that if someone is doing a thesis on this or is working in this area, these are must reads. I mean, there's no way you can avoid this. So mine is just to say sort of 3 reflections in this short time that I have. One is how I saw the book as a scorecard. The second one is reflecting a bit on Africanization. And the third is what I would label as Kidane's pragmatism. And I've thought that this is how he has been writing even before. And maybe I'm saying this to him with a wider audience for the first time. When I read the book as a scorecard, I sort of even said that if I had done it, I would do a table. Because for me as a Kenyan, I said, okay, now we have these 3 cases. This is how we have performed. I think, you know, if you come from Nigeria, you can see you might have been lucky with 1 or 2, but PID, the recent case was very bad. And you could see how you can traverse and see the cases from Zimbabwe to all over the continent on how African countries have performed. And I thought that was a very interesting and significant contribution. And I really, really loved it. No one has done this. At least no one has done this for us to just do all this hard work of putting these cases together and analyzing them within the framework that this has been done. The second point on Africanization, at least I have written using James Gathi's work that we have now sort of maybe 3 types of Africanization in investments as I see them. The contributionism aspect of Africanization. Then we have, what I have then labeled agnostic Africanization, and then we have critical Africanization. And one in the chapter where he's dealing with the school of thought also has a 3 labeling system as a heuristic, which I also found very interesting. That to understand the character of this system, you have to think about the ideological school of thought, the doctrinal school of thought, and the hierarchical school of thought. And my immediate inkling was to say, where does one fit into this 3 sort of school of thought? And I was scared because it actually might be a mixed grade. But I have labeled Bissie's work, especially when he did reverse contributionism, as being agnostic. And I thought that one's work, the book itself, is in a large sense an expansion of reverse contributionism that Bissie has done. And for that reason, I think that one's work in my labeling is agnostic Africanization. So that's where I will leave that there. Lastly, on pragmatism, when I read the work that one had done, including on legal cultures previously, contrasting with what we Twailers have done, I have always thought that even from just the presentation he has given today, one's work is very, very pragmatic. If you read the chapters, especially on substantive content, it just says this is what is happening, and this is the truth about the challenges that Africans are facing. I think when also I read the paper on dilemmas, you also are being very pragmatic. And I think one of the huge contributions that even this work pushes forward, at least from me, from where I was reading, is the pragmatism. I think I might leave it there for now because there's just so much that we can discuss here. So let me stop there, Bissie, before you stop me, and then we will also have another time to contribute. Thank you.
Okay, Harrison, thank you very much. It's interesting you come with these typologies, right? That they are provocative in themselves, and there's really not always a lot of time to discuss them. But thank you very much for engagement with the book and for putting those thoughts on the table. I was hoping for the sake of our audience, I could get your article quickly. Maybe I'll still put the link on there after I pass on to the next question, so that they can they can by themselves at least familiarize with these concepts that you have given us. But in the interim, I'll move to Dr. Olaoye. I know you have written also a lot, about international investment law. Your doctoral thesis engages with these. You've thought about it deeply in the West African context and continue to do even so beyond that. And so, putting Professor Dagbanja's book at the center of your own intervention, I wonder, where you see this in the context of this, thematic, normative, theoretical orientation of his public interests regulation and international law. He says, there's this thing about imperative theory of law that he's put at the center of his work. But I wonder what your thoughts are arising from your engagement with it. Thank you.
So thank you, everyone, and thank you for the audience who is joining us. And of course, congratulations to Professor Kidane and Professor Dagbanja. So very, very briefly, within West Africa, as we all know, we have several regional organizations. So we have ECOWAS, which is the Economic Community of West African States. We also have the West African Economic and Monetary Union. And of course, we also have OHADA. And the interesting thing is all these systems, especially ECOWAS, have their own specialized rules on investment. Within ECOWAS, we have an energy protocol, we have an additional act on investment, and more recently, we have the ECOWIC and the ECOPIP. Now, the thing is, within Professor Dagbanja's work, we don't really see, these references to regionalism within Africa. The focus is more on international investment agreements. However, because of his strong focus on public interest regulation, it helps me to ponder and think and ask. So if Domestic courts, for example, should be, the prime alternative for settling disputes. What happens to the regional courts? And when we look at recent cases by the ECOWAS Court of Justice, we see how the domestic courts are very, very inadequate. For example, we have, a recent dispute, which involves Sierra Leone. We also have another dispute involving Ghana and a public interest body in Ghana. And basically, in these two disputes before ECOWAS, of course, we know that the ECOWAS courts were designed as trade courts, as economic integration courts, but in practice, they operate as human rights courts and also operate as courts for settling employment disputes. So the question, of course, is how, I think this will be, a very, very good question to Professor Dagbanja. How can we ensure that these mechanisms that we have at the regional level ensure that states are held responsible? And of course, this also forces us to realize that we have foreign investors, we have domestic investors also count, and we have regional investors. What happens to the Ghanaian investor who wants to invest in Nigeria? What happens to the South African investor who wants to invest in Senegal? Should these investors be treated differently from, for example, the European investor? Should these investors be treated differently or less, even less, receive less treatment than the investor from the United States? So overall, just very, very briefly, I would say, he raises very, very important issues, but the main question is, how do we ensure that we hold sovereigns responsible? How do we ensure that states remain responsible and uphold the rights of citizens under constitutional law? Thank you.
Thank you so much. I like what the panelists are doing to start with. They're helping us with time. So that's pretty excellent. But beyond time, they're actually putting very thoughtful, deliberations and reflections on the table. So Professor Dr. Lau invites us back to I think what I would recast as, the fundamentals of contracts, and honoring your agreements, but also the responsibility to balance it with public interest, which is at the heart of Professor Dagbanja's book. We'll come back to all of this thought in a short while, but I do want to also move along to Professor Ibironke Odumosu-Ayanu, who, as we know, has written significantly in this field as well. And so, Professor Odumosu-Ayanu, given the fact that, you have also engaged with actually both books, I do know, and in view of your own, expanded work in this area, where do you see, if at all, there are, for example, overlaps in these works, and what divergences, if at all, might there be from the work that you have engaged with? Thank you.
Thank you very much, BC, and the organizers at Acronomics. But BC, I'm going to take my 5 minutes because you're asking me a bigger question than you asked Harrison and Kende. So I'll take my 5 minutes. This is 2 books now, and this is not 1 book. So first, I'd like to say big congratulations to both Dominic and Juan. It was such a pleasure and a great opportunity for me to actually read both books. Personally, for me, I've studied ICSID, so Juan's book resonated. Going through the history of ICSID again, that was fascinating. And Dominic's book, clear, critical approach that I always appreciate. So that was just a pleasure to read as well. As much as possible, I will try in these reflections not to repeat the author's introductions to their books. So secondly, BC, as you asked, there are overlaps in the books, at least to the extent that both of them address the subject of international investment law in Africa. And so, for example, I would say that even Dominic's book does turn some attention to some of the regional work, but not in the same way as Juan's book, for example. So Juan's book does separate chapters on some of the regional frameworks, while what Dominic does is, so for example, if he's looking at human rights or if he's looking at ISDS, he's saying, okay, these are some of the things that are going on regionally. So his focus is more thematic rather than regional. So in that sense, that's a bit of a difference. But in terms of a substantive overlap, and it's the recognition of the centrality of the state's right to regulate. Quite close to the beginning of one's book, it was page 19, where he was talking about resolving the challenges in seeking to promote states' rights to regulate on the one hand, versus investment protection on the other hand, being what he calls, and I'm quoting here, the most contemporary, dominant, and mainstream debate. He identifies that very clearly close to the beginning of his book. And that really is at the center of one's book. So I would say that to the extent that there is overlap in this works, is that recognition by one and the focus on that recognition by Dominic in his work. And if you go close to the beginning of one's book as well, he cites the, I don't know what to call it, the infamous decision in Von Pezel and Zimbabwe, noting how that case focused on constitutional land reform in Zimbabwe. That's how he starts his conclusion. And that whole constitutionality issue is what is at the very heart of Dominic's work. But now to kind of go to the divergences now. Before I go to the substantive divergences, we started to hear some of it. I like the way Harrison characterizes one's book as being pragmatic, right? Dominic's work is a lot more critical. So if you kind of want to do a spectrum of analytical, normative, and critical, I won't get into that. My 5 minutes is getting close to the end. They go through a different level of analysis on that spectrum of analytical, normative, and critical. But they both turn to the future of Africa's intervention in international investment law, albeit in very different ways. In terms of difference as well, as I was reading, because interestingly, I read Dominic's book first. If I had known the content, I might have done a reverse order, but I read Dominic's book first. And one of the questions I had as I read Dominic's book, I found answers to in one's book, was more of a direct analysis of the political economy of investment treaties in Africa. So Dominic advises African states not to do a number of things that he was talking about earlier that I won't repeat. And the question kept coming to mind, well, why do they keep doing these things, right? So he harkens back, for example, I think it was one that did that. I'm sorry, I've read both books together. One of them harkens back to the new international economic order and how African states did a roundabout and started to sign bilateral investment treaties that were very different from the contents of the NIEO, right? Those were some of the things that I was looking for in terms of why do African states do what African states do? So the political economy of international investment law. Dominic's book, as is mentioned, includes an extensive analysis of a conceptual framework, as he mentioned, that he refers to as imperatives theory, and I found that significantly fascinating. And then he uses that as a segue to get into his analysis of constitutional and general international law and how they inform this area. And one issue that Dominic did not get into in his introduction that I hope we would have some time to deal with here, which is quite different from the way that one approaches
Professor
where
you still have I've given I'm abusing my moderators that and I've given you extra 3 minutes.
Okay, thank
you're putting
you.
both together. It's
Because
only
I'm doing 2 books at the same time. Thank you. So one issue that Dominic doesn't get into in his introduction, that he didn't get into in his introduction earlier, are his recommendations for going forward. And that's one area where his work is quite different from one's work. So Dominic argues, and he notes correctly, controversially in some circles, he argues against national treatment. So it does say that African states should no longer include national treatment provisions in their investment treaties. African states should no longer include most favored nation treatment provisions in their investment treaties. And it gives compelling arguments as to why this shouldn't be the case, referring to, in the case of national treatment, domestic investors, that why states may want to treat domestic investors differently. But then there are counter arguments to that as well, issues around discrimination. And then it gets into most favored nation treatment. If there's going to be that clause, then why would a state pay significant attention to its negotiations? Once you've done something in one treaty, you might as well forget about it because it tends to apply across board. So he argues against the most favored nation treatment as well. He argues for limitations on fair and equitable treatment in investment treaties going forward. And sometimes, and I do say sometimes advisedly, he argues for the abandonment of investor-state dispute settlement. Because at some point in the book, earlier in the work, it seems that Dominic is arguing for a significant limitation to ISDS. But by the end of the book, he's taking a clear position that, look, away with the system. So that's why I say sometimes he argues for the abandonment of investor-state dispute settlement. And all of these flow from what he refers to as that imperatives theory and his reading of the constitutional provisions of 5 African states, as well as what he calls general international law. These are all significant shifts that, if they were to happen, will be massive shifts. I think it was, because I did read the preface as well, it was James Gaffey in his preface, or the foreword, that's in the foreword now, that said, Dominic doesn't argue for the abandonment of the system. But then the question I have for Dominic is, with all of these changes, what does that system look like? I'm not saying I disagree, but what remains of the system? And I'm going to leave it at that for now.
Thank you very, very much, Professor Odumosu, and very interesting remarks on both books. What I think I want to restate to all of our participants is it's difficult to try to put all of the excellent works that these both books have done in any kind of short conversation. So ultimately, we hope that if you're here doing your PhD, you'll find a way to engage with them. If you're here, you're a faculty member, you'll get your library to get copies, or tell your friends to get copies in their libraries, and so on and so forth. But these are very interesting thoughts that are on the table. And I think, I would like to alter our plan a little bit here. I don't think it's fair to leave the authors hanging until the end of the second round of interventions. There might just be a lot for them to have to respond to. So I'd like to give, what is maybe 3 minutes maximum. You don't have to respond to all questions, but if there's any burning point you want to quickly put on the table in 3 minutes each, that would be excellent. Dominic, do you want to start first?
All right, thank you so much, Kehinde, for the generous review and comment made, as well as Ronke for the critical review made and the suggestions that you have made and the question that you have raised. On the question of investor-state arbitration, well, my question is, if you pick the Nigerian Constitution and you find that the Nigerian High Court has jurisdiction, or the Nigerian Supreme Court has jurisdiction over a dispute that Nigeria has signed, given that jurisdiction to international arbitral body, there is a constitutional question to resolve as to whether or not Nigeria constitutionally can oust the courts of its jurisdiction. And we need to address that question if the Constitution is of relevance to the governance of African countries. And so, but in any case, in my book, I made suggestions around state-state arbitration. And in particular, I said that there's no difference between, if you look at, there's a book, I can't easily find it, but there's a book addressing the synergy between international trade and investment law. And we find that the same investor that is engaged in maybe a form of investment could also be engaged in trade. And yet we have a dichotomy between the WTO dispute settlement mechanism and investor-state arbitration. So one of the points that I suggested is state-state arbitration to address this question that the investor may be dissatisfied with the dispute settlement mechanism at the domestic level. And if there is a need for a mechanism outside at the state level, then my proposal in the book is for a state-state, dispute settlement mechanism. And I'm saying that we should construct a regime within the African continent that addresses both trade and investment dispute. We shouldn't have different systems for trade, different systems for investment. So I made up that proposal given the synergy between trade and investment. And I'm saying that there's no reason whatsoever that a foreign investor that is located within the African continent, in Nigeria, in Ghana, will travel to Washington, D.C., in the UK to settle their dispute. There's no reason whatsoever. So we should ensure that we have domestic and regional systems that are effective in resolving dispute between foreign investors and state. And we should remember that this is a post-colonial regime. International investment law is a post-colonial regime. When the colonial masters were there, they were using the imperial legal system to protect their investment. And so the system of investor-state arbitration essentially was to replace, the loss of imperial regimes. I think we cannot continue to run this system that does not serve our interests. Okay. On the question of what remains in place, allow me to conclude.
With time. I'm sorry, Dominic. I'll be straight. We now have a lot of interesting questions, which we would like to get to. I imagine you all would like to have those engagements rather than have you speak to your own thoughts on this. So apologies. I don't like to do this usually.
Very well.
Okay, all right. Thank you for your understanding. Okay, on now to Professor Kidane. Your own 3 minutes takes us to the top of the hour.
Yeah, thank you very much. So I'd like to thank both Harrison and Bronke for excellent analysis. And I didn't expect anyone to actually read the whole thing. It's 600 pages and offer very thoughtful points. The pragmatism that you both indicated comes from my own realization of the Africa's economic circumstances, really. One of the things that they talked about in Addis Ababa in 1964 was this is essentially a World Bank project, right? Exit. So implicit in the whole acceptance of the whole system is if you don't play by the rules, the principal financier of infrastructure in Africa may not be very happy about it. So that's the signal that was sent back then. And it continues to be the same. We may not be able to find specific data backing up this investor actually invested because of the existence of this bilateral investment treaty. But it's very obvious that when lenders and other financial institutions look at the legal infrastructure overall, their decisions are somewhat impacted, and there's almost no doubt about that. So you want to portray this image that you are a modern state, you have legal infrastructure and the whole thing to treat investors the way they need to be treated. Now, the problem has been, if you look at these cases, the problem has always been, I believe, what is called the phenomenon of the briefcase investor. Those are investors who actually try to take advantage of these treaties. They consider, as I say somewhere in the book, the treaties as some type of political insurance for the investment. In most cases, disputes arise because what is expected, like there is a genuine business failure and someone has to be blamed for that. And I say in the book that in many cases, tribunals almost consistently do this. They offer the benefit of doubt to the investor. They don't necessarily seek to harm the African state, but in case of doubt, they tend, in most cases, in almost the significant proportion of the cases where Africans lose, it is about deferring to the investor in many different ways, and that also has to do with the decision makers. That we can get back to that, but that's really so. The pragmatism is the total boycott. We've seen it the first 2 decades, as I said. If you don't show up and you defend the case against you, then you will lose. And that's where I saw that once the Africans started hiring good lawyers, whether it's out of New York, Washington, or and started defending themselves, and then things started to change. If you look at the scorecard, it's evenly balanced. And I can only identify very few cases where I thought, oh, this tribunal shouldn't have actually decided, and there's bias in this case, or there's some type of application of rules. Most tribunals are actually reasonable. Most tribunals are rational. And of course, that level of rationality and reasonableness does not depend on one's nationality. That we could be sure about.
Hey, Professor Kidane, I have to jump in here. Thank you very much. I see Harrison, itching seriously there to jump in, but I won't immediately buy that. Okay, so, we have about 29 minutes. I want to be most effective with time here. Our panelists have a very sharp 5 minutes. If you can keep it under 5 minutes, that'll be excellent in the second round, and then we'll go to the Q&A. And so I'll start with Professor Odumosu Ayano here. You've raised issues coming out of Professor Dagbanja's book on the broad themes of, intersections of right to development, human rights, and environment. These are subjects you've, of course, written on, and I wonder what more you can share, maybe continuing from the thoughts you started with on their potential shortcomings of working these, especially in view of the points Professor Kidane, in fact, just made about the operation of the system currently.
Thank you very much, BC. So I'll try to keep this one really short. So this is where I'll go with human rights in international investment law. So I did read Professor Kidane's book and got to see the data, but and I start with a but. There's a lot about the international investment system, as Dominic notes, Professor Dagbanja notes in his work, that needs to be addressed. And one of it is human rights, as Professor Dagbanja correctly noted in his work. And yes, if one looks at the human rights record before investment tribunals today, for example, there are sometimes references to human rights, and even some newer treaties do. But those of us that take a critical look at international investment law are of the view that a lot of work remains to be done in mainstreaming human rights in investment law. But I would say that before we even get too far, my position is that there is a lot to be done before we even seek to start to mainstream human rights in a system that is undergoing a lot of contention. So there is a lot of contention that surrounds this area, as Professor Dagbanja notes very ably in his work. But then the data, when you look at Professor Kidane's work, appears to show something. But there is a lot going on here. So this is my take very quickly. I want to get away from, I want to talk about this in less than the 5 minutes. We're seeing a lot of extraterritorial litigation in the home states of foreign investors by the people whose rights are affected. It says that there's something going on. Even Canada has seen a big case that was well talked about from Eritrea, right? We have the Lungowe case in the United Kingdom. We have the cases from Nigeria before the Dutch Supreme Court in the United Kingdom. We have the Nigerian cases in the US. It tells you that there's something going on. It's all foreign investors. It might not be ISDS, but it tells you that there's a human rights element here that may not be clearly grasped when we look at the ISDS cases. So for me, I would say that it is necessary to revisit the underlying framework of this area. So first, that investor-state nature of this area needs rethinking. It's a system that reads out everything else from within its realm. It just kind of thinks about the state. And for those who have theorized the post-colonial African state, there's a lot of unpacking to be done there, right? So if we just kind of focus on the state and the investor, we miss a lot, right? So I think that investor-state nature of international investment law requires rethinking. And the second and the last thought here is that idea that investment protection is the single interest to which all other legitimate interests, including human rights protection, must be subjected, needs to be rethought. Because that's the framework for international investment law. As Professor Kidane noted even a few minutes ago, the benefit of doubt is given to the investor. So investment protection is central, and every other legitimate interest is then subjected to this investment protection to see if it passes the test. We need to walk away from that and at least keep all legitimate interests on the same level and not measure them against one interest.
Thank you very much, Professor Odimoso. So I can say something now, which I think the editors of Afronomics Law would not ask me, it would not say I've spoken out of turn. You can look forward to a symposium, actually, from maybe upper week on the Multilateral Investment Court and Africa, right? Totally different audience from those you're seeing here on the screen and maybe in the audience as well. So some of these questions may well have been taken up in that symposium. But let me now go straight to Harrison, right? Amongst all the excellent issues that have been discussed, arising from Professor Kidane's book, there's a deliberate focus in this book on African regional investment law regimes, discussed over various chapters quite intently. So I wonder if you want to highlight, anything that has occurred to you, especially in the AFCFTA investment protocol, which he started, touching at some of the very funny, quote unquote, provisions in there that sought to replace FET, or indeed, how you see this operating, if at all it has to, with the Pan-African Investment Code that never saw the legal light of day. Thank you. Your own 5 or 4 minutes starts now.
Okay, thank you. I want to do this quickly because I think this is my bigger question. And to first state that I think even by the time Warren wrote the book and what we have as the current, our most recent version of the protocol, a couple of things have changed, including the fact that for, FET, which we are now calling administration and judicial treatment, the second provision right there for customary international law as a minimum standard, I think was removed. And I might have been mixing drafts because I've kept on looking and following drafts and seeing how these drafts have changed. And it's very interesting to note. The second thing to note is that we have this, innovative language of for greater certainty in that protocol. And for me, once I see that, I know that we are trying to do what the global north has been trying to do, to tinker. If we tinker, it will become better. And some of us have said it won't. No matter how much certainty, no matter how much for greater certainty we had into this document. And I did control fine and I had like 9. I think there might even be more for greater certainties. But in terms of framework, I think there are 3 sort of an analytical framework that I have. And because of time, I'll just deal with the most important ones. I think that the first analytical framework is that we are now moving for both PIKE and the protocol towards balancing provisions. And this is what I've been talking about. And some, I think scholars like Sonraja have already told us that this thing cannot be balanced. And I believe it can't. Then we have the reformist and rejectionist substantive provisions, including saying no FET anymore. We're not going to deal with full protection and security. Ours is going to be physical protection and security. There's that a move there. And finally is the procedural backlash provisions. So that for me are the 3 sort of analytical frameworks. And I wanted to sort of see what has happened. For the first one, I would say that the most important, and I think even Dominic work deals with this a lot, is this question of the right to regulate. And PIKE is big on the right to regulate and sustainable development. And I tend to think it's also because of the time it was written, there was this buzz for sustainable development. I think that the FCFTA protocol seems to be a little bit skeptical about sustainable development compared to PIKE. That's number one. you see, PIKE has certain, there's provisions on role of women and youth. I think that is somehow extended to some extent into investor obligations and all these provisions, even in the protocol. So both of them are very robust on investor obligations, and there's so much just in terms of African contribution. There are many provisions on investor obligations. I would say that maybe those two for now for balancing, but there's much more. When it comes to the reformist and rejectionist substantive provisions, I'll say, yeah, exceptions to MFN and exceptions to national treatment are present in both. I think that the only difference is that the exception to MFN in the protocol is specific to dispute settlement as an exception. I don't think whether these exceptions help, especially for someone who thinks the system should be rejected anyway. You can imagine, it doesn't matter how much you change it. But lastly, which is my last framework, and I had many more things to say on this, and it's good, BC, you asked me this question. Maybe there is work to do, a lot of work to do, is this procedural backlash provision. So Dominic has mentioned this. PIKE is front-loading state v state. And I think the protocol is even further saying that we must go back to state v state dispute settlement. That is where we should go. PIKE has exhaustion of domestic remedies. I don't think the FCFTA has exhaustion of domestic remedies, and it's mainly because it said, things that are in the annex, we will discuss that later. And it's, for me, an express deferral, as one said in his book. Let's see what comes later. We are kicking the can. We have to decide. At one point, we have to decide where we will go with this. I like the fact that PIKE centered African dispute resolution centers, which Dominic has really emphasized. And because we kicked the can with the protocol, we don't know whether the protocol is centering African dispute resolution centers for dispute settlement. Lastly, I think PIKE also centered this fork in the road clause. If you decide you're going to for arbitration and state v state, that's it. And because, again, we kicked the can with the FCFTA protocol, we don't know clearly what was negotiated and why we are there. This deferral has made the protocol a little bit difficult to therefore discuss in that sense. And I see my time is up. Thank you, BC. I don't want you to stop me.
No, thank you. I hope I did not. Huh?
No, you didn't.
So thank you very much. There's just a lot to discuss, but I think the purpose of this conversation, and I think Professor Kidane has mentioned about it, there's just a lot to write. And to really write from our own voice and from our own perspective. We don't need any other people to do this for us. So please write as many of these issues as have been spoiled and engage with the authors. Disagree with them if you like, or agree with them as appropriate in your own thoughts. So I go on now to Dr. Olaoye. For the last question, I do know you've written on ECOWAS investment regime. You've started hinting at that a little bit as one of the regional African investment law regimes. So given the fact that you've given, some thoughts to that particular regime and the fact that it hasn't quite, generated as much literary engagement, scholarly engagement, I do wonder what your thoughts are emerging from the contributions on Pan-African investment regime chapter, especially from Professor Kidane's book. You have 5 minutes now. We'll move on to Q&A.
Okay.
Sorry.
My apologies. Okay. So please let me refer to page 418 of Professor Kidane's book, where he states that the AIP strictly forbids the conclusion of any new BITs. It is, however, more forgiving to regional investment agreements. The resolution that AIP, the African Investment Protocol, offers remains a matter of regional grace. This is what he says. Very graceful words, but very, very pragmatic, as everyone has highlighted. And reference to this, of course, is Article 49 of the Investment Protocol. Now, of course, the question is what happens in the future? And, ECOWAS, of course, is a glaring example of the fact that at the regional level, a lot is going on. We have, the AAC, we have the SADC, which Professor Kidane also examines, which is, a totally different political economy in terms of how it, developed its own laws, a very, very different history, which is, of course, very different from the West African context. Now, of course, the question then is, how do we deal with this? In previous scholarship that has been done by African scholars, including Professor Gatti and Professor Opong, we've, learned a lot about what's called overlapping regionalism. And this, remains a problem. So the question then is, how do we move forward? How do we, deal with these things? And the investment protocol uses very, very, very weak language, if I must say, saying, shall try their best, nothing, very, very strong. And this sort of gives us an indication of some of the compromises that have been made at the continental level because of the fact that we still have 8 regional economic communities which are recognized under the African Union, and the fact that the Lagos Treaty of 1992 and the realization of a full African Economic Union still remains an outstanding ambition for the continent. Thank you.
Fascinating. Thank you very much. So, because of the way you ended, there's an event that I think the ECA, policy, and we retweeted it on Afronomics Law, is doing January 16th, I think, to 20th, that seeks to engage with challenges in implementation of the AFCFTA. These conversations are all interwoven. As you can see, Professor Olaye's intervention draws our attention to these other regimes with deep historical roots.
Please let me just add just one thing, which I would just like to, draw our attention to. And this is the Samoa Agreement, which is the post-Cotonou Agreement, which was signed in November 2023. We also have the EU-Angola Sustainable Investment Facilitation Agreement. So if we're thinking of the African continent as one region, and what is happening outside, then we should definitely look at these agreements, which sort of differ, which are very, very different from what you find within the Pan-African Investment Code and what you find in the investment protocol. So I just wanted to add that. Thank you.
Okay, thanks a lot. Indeed, these new agreements that have been concluded bilaterally raise serious questions. So I want to ask for the author's indulgence in how we frame these remaining minutes that we have. You will have the last say as authors, for sure, but you've also had questions in the chat. So to sort of just reorder it and start with, I want to invite Dr. Fola Adeleke to come on briefly and pose his own question. Dr. Adeleke had also written his own book on international investment law in Africa and human rights. And so, yeah, Dr. Adeleke, do you want to quickly pose your question so that we can have it taken up?
Thank you, Professor BC, and thank you to the authors and panelists for this very fascinating conversation. There's a lot to explore here and to continue to reflect on. But one quick question that I just had for Professor Kidane relates to the sobering statistics that you provided in relation to the arbitration of the 88 cases. States and investors have more or less equal opportunity to choose their own arbitrators in deciding cases. So if you have only 4 Africans having participated in deciding those cases, what does that say to the complicity of African states in shunning their own in the resolution of disputes? Does that speak to the paucity of the skills and capacity on the continent in relation to of investment disputes? But also broadly, can you reflect on your own thoughts about whether the nature or the background of arbitrators would really shift how a decision is concluded? Why do we need to focus on the nationality of arbitrators, and why do you think those have a significant impact on the resolution of disputes? Thank you.
Thank you very much, Dr. Adeleke. And your own book was written in 2018, but we've put it in the chat for those who may not have known about it as well. So for Dominic and for Juan, and indeed for our panelists, what I want to sort of invite is, since there might not be otherwise pinpointed questions for our authors, while Professor Kidane is responding, I'll please invite you to sort of indicate to me privately in the chat which of the questions you'd like to give a 2 minutes broad take on, so that we can sort of democratize the questions and then come back to the authors for their final reflection. Thank you very much. Yes, Professor Kidane, do you want to comment on that?
Yes, thanks, Fola, for this question. That's obviously a question that we get asked all the time. And the answer really lies in our understanding of history. I think it's a function of legacy. And the reason why the decisions, when at the beginning of my remarks, and I said, what the regime does is two things: introduce external legal standards and outsource the decision-making process. So it's that is what it does. So it's a World Bank system, right? It's in Washington. When a dispute arises, it's resolved in Washington, and the procedures have to be accepted here. That's where I am right now. And most importantly, this is what, not a lot of people pay attention to that. It's obvious. The chair of the tribunal is actually the defaulting appointment right resides with the chair of the Administrative Council of the World Bank. That is the president of the World Bank. So the single most important authority in any type of decision-making is the right to appoint the chair. So if you know who the chair is going to appoint, then you are constrained by that choice as to whom you can appoint. Now, people who are responsible for managing individual cases, they're not out there to diversify the pool of arbitrators. They're there to win a case on behalf of their client. So the consideration that individual lawyers or groups that represent states have is a completely different consideration or set of considerations. So an African as an arbitrator, or an Asian or a Latin American may not in that particular instance make sense. It all depends on what the lawyers think, how the dynamics of the tribunal is going to work in each individual case. So unfortunately for Africa, those considerations lead to the appointment of some of the most prominent arbitrators in all of these cases. Right. Now, let me say this. There is nothing fundamentally wrong with that process of appointing whoever you choose to appoint in any particular case, right? It becomes a problem when you look at it from a systemic point of view, from the whole system. Oh, why did we end up with 80 arbitrators from the West out of 88? That's more than 90% or close to that. So my response really is, it's a very complicated situation. It's linked to history. It's linked to the very establishment of the system, where it is, how it functions. So it's a combination of all of these things. You can't really fault each individual representative of the state for making the choices that they've made in that particular case or in those particular cases.
Thank you. Thank you.
More about it, and of course, I've written a book on how decisions are made, science of persuasion, culture, and all of that. So I don't think I have time to get into that, but that's what I want to say this one.
Yeah, thank you so much, Professor Kidane. I mean, again, it's just worth repeating. Please do, if you are interested in these issues, familiarize yourself with the body of works that these expert panelists have put together. There's a lot in there to chew on and engage with. Now, I haven't gotten a take from the panelists directly on how the questions should go or which one they want to work with. So I'll just revert and start with the one that was first put to us by one of our very present Afronomics Law community members. That's Dr. Kimani Goddard. Her question is, might we consider the question of whether BITs or IIAs, when all balanced with public interest, provide a public legal signal of minimum standards of foreign investments, and can, where properly implemented, constrain the excesses that are ubiquitous to in its state investment contract? Where IIAs do not exist, foreign investment is executed through confidential state investment contracts, which are prone to abuse because of that confidentiality. So it goes on at the end of the day, says this includes public interest and development investment standards. Now, it starts with a question and almost ends with, a reflection, mini reflection. Dominic, do you want a quick take on that in addition to any of the other questions that are already there that I think does the work? Or I already see, Dr. Laoye, indicating, so I can really respect that first and come back to you, since you will be one of those who have the last say as an author. Okay, so you can hold on for now, and we'll let Dr. Laoye take this. Okay, thank you.
So thank you very much for that question. I think it's a really, really good question, which ties into some of the work that, of course, has been done by the authors. So, for example, when we look at Professor Dominic's book, we find that, the main reason why he, this is me second guessing, but the main reason why he chose to do this was because of the types of, disputes that were emerging in the context of Ghana's constitution. And as we all know, Ghana, has a history of, exploration of gold mines, and things like that. And so the 1992 constitution, which, was chaired, the drafting committee was chaired by XKB Asante. The main reason why this was done was not because of international investment agreements. It was done because of investment contracts. This was the main reason why Section 182 was inserted into the Ghanaian constitution. And the idea, of course, is, that we should focus on these contracts. These contracts have a historical premise, from the colonial era, and renegation of this contract. And, if you read the work of other scholars like, SKB Asante, Professor Sonaraja as well, we find, very, very clearly that this continues to date. So, in Professor Sonaraja's work, for example, he refers to, the continuing battle and, the false idea of the international contract. But, the question, of course, which is, very, very pertinent in what you say is that, and I agree completely with you. So the answer is yes. I agree with you 100%. Yes, investment treaties can actually ensure that investor-state contracts are not abused. Investor, contracts usually remain confidential, usually go through arbitration, and often, some instances will not involve interpretation of, international investment treaties. So the answer is yes, and I will just stop here because, but feel free, if you, want to have more discussions or, about this, please, feel free to message me and we can continue the conversation later on.
Thank you so much, Dr. Laoye. Indeed, it would be great if you can get in touch with our panelists. So I'll move on now to Dr. Mbori, who has offered to take on one of the questions as well. Yes, thank you. Sorry, before you answer, may I just say to our audience, we thank you so much, right, for your patience. All I'll ask for is an overtime of just about 7 minutes. And it won't be beyond that. So thank you so much. If you can at least bear with me for extra 7 minutes beyond that time. Yes.
Yes, I wanted to attempt this question on this constitutional, transplantation from colonial constitutions. And this is something that I thought was very interesting when I read Dominic's book. First, I thought that, the selection sample needed to, for me at least, be explained. I think if you take Kenya and Ghana, just two good examples, you might get very strong constitutional democracies with, for example, Kenya's 2010 constitution, and which might have pushed then Dominic's constitutional imperative argument very well. But if you take more complicated cases, and I think he took one, for example, like Egypt, but there might even be more complicated cases like, I would say Tanzania is a complicated case. I would say Ethiopia is a complicated case. The political economy of African countries' constitutions are very, very different. But even if you take Kenya's constitution, for example, say this is a strong constitutional democracy, there is strong property rights, you can then push for a strong public policy process, you end up with a very complicated scenario because while you get a very strong constitution that, you know, has very strong public policy orientation that protects the people from constitutional imperatives, point like Dominic says, if you go now to company law, investment law, these economic law systems that then really affect investment, you find complete, sometimes like in Kenya now, we are studying complete colonial transplantation. In fact, for us, we copy-pasted the UK Companies Act and the UK Insolvency Act, copy-paste, direct copy-paste. So then you wonder what kinds of problems you'll have. So the answer to this question is, even in cases where there's no direct constitutional transplantation, you still end up with in some problems with other laws. And therefore it can become very complicated when you start just saying, is it constitutional transplantation or is it other laws transplantation? Yeah, thanks.
Okay, thank you very much indeed for your attempt, Dr. Mbori. So this is usually, again, what I do, and you're like, oh my gosh, I wish there was time to address all these excellent questions that I put out there. But the truth is, we don't want to abuse your time. This is Saturday. Professor Dagbanja has joined us from where it's almost morning, you know, in another part of the world, and you all are still hanging with us significantly. So what I like to do is to say, if your questions have not been answered here, there'll be opportunity. Please write to all the panelists with your questions. I'm sure they'll welcome them. Even if they can't engage with them in email, they will direct some way to you their thoughts on it. But before we conclude, I'd like, you know, Dr. Dagbanja and Professor Kidane to have, you know, if it can now just be 1.5 minutes, please, so that we'll not go beyond the time I've indicated to our audience, to whatever thought you want to conclude on beyond the book. You are at will, right? It doesn't have to be anything here, but I do want you to have the last substantive say before I conclude. Dr. Dagbanja.
Thank you. Let me say thank you once again for the opportunity to be part of this very rich conversation. So I think that we need to go to the fundamentals. Okay, that foreign investment leads to development, and therefore we need investment treaties to attract foreign investment and provide the legal protection. But we need to realize that no nation develops by opening up its borders to foreign investment. This is so I think that the protection that foreign investment and the legal treaties need to be effective against the benefits right from there. We need to remember that this is a colonial regime. So I think that African countries need to reassess how we can move from, for example, looking at immigration law, that the developed world that has constructed a free investment regime, and the assistance between our counterparts, they are very strict when it comes to immigration. I think the panelists here, all of us have discussed, we have committed to and we are making significant contributions, but we are subject to domestic law. So how can it be that a foreign investor can Nigeria, in other parts of the world, not necessarily protect us, but what I'm saying is foreign investment as a we need to accept the benefits of foreign investment protection against the risks associated with that. Thank you.
I'd like to say that most is a shortcut. And I think we can get this right with the right level of sophisticated inquiry. And Africa is getting there. The economy is growing. It's being more attractive. And it can continue to play by the rules. It has played by the rules in the last several decades. And it's now in a better position to be negotiating these contracts, to be negotiating these treaties. But for reformers, I'd like to say a few words, and I'll just read what I've said in my book. Reformers should always be mindful that who decides and under what checks and balances is more important than under what rules. As encapsulated by Gary Peller's eloquent note in his famous article, The Metaphysics of American Law, it is a commonplace that law is political. Ever since the realists debunked formalism in legal reasoning, the received learning has been that legal analysis cannot be neutral and determinate, that general propositions of law cannot decide particular cases. Some policy judgment or value necessarily intervenes. It is a transcendental nonsense to believe that it could be any other way. So the FCFTA protocol omitted the most important part of the whole equation, which is the decision-making process. And I hope they get that right. Thank you.
Wow. Okay. What I don't want to say to start with in conclusion is, thank you so much to indeed, first the authors and to all our panelists. I have benefited from all of your thoughts expressed in writing. And, I'm sure our audience have also done that. And so for all the time you've given to share so much of your thoughts with us in print, thank you. But there's a lot to discuss as they put on the table. I'm thinking about this and, we haven't even mentioned critical raw materials and the type of investments that is going on into them. The invocation of national security, a national screening of investments that's going on all around the global north right now. There are so many more questions. And I think where I'd like to have it left on behalf of all the editors of Economics Law is that you are welcome to write on these issues. We have this platform which belongs to all of us to share these issues, to share these thoughts, to have these conversations on our own terms, and to say thank you so much for the time you've shared with us this Saturday, and hope to see you soon again. We'll have a next one in about another 2 months or so on a different issue. On behalf of all our editors, thank you so much, and thank you very much.
Thank you. Thank you.